listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I am Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
We're sitting in the car.
We're sitting in a
to record the podcast.
outside the courthouse.
Yes, in between court.
In between court appearances. So that's why you don't have us on video today. It's just audio. Sorry about that.
You look acceptable. You look like you could go to court, but I look pretty rough.
Yeah, that was my other consideration,
Yeah.
but I didn't want to say that. But now that you've said it.
You look like crazy old version of like Clint Eastwood when he was starting to get old.
Yeah.
Crazy.
Your eyes are a little red. I don't think you slept well, so you also got like some Gerard Depardieu going on.
Oh, good.
Yeah.
Somebody commented on TikTok that I looked a little bit like Clint Eastwood in something, and I used one of those face filters the other day. Who's your match? And it said Keanu Reeves, and the second time it said Clint Eastwood, and I'm like, okay, is this because I'm Canadian, the Keanu Reeves? And then
Who knows?
anyway, so maybe I'm the love child of Keanu Reeves and Clint Eastwood.
Yeah. Anyway, big news this week that you don't think impacts driving law, but it does.
Let's hear about it.
It is Bill C-16 from the federal government, which is a massive criminal law overhaul bill.
Surprising because this is the second one in the pipeline, criminal law overhaul bill. This is like the first one was announced a while back, and they haven't passed any legislation yet because they haven't had a majority, and so everything's sort of stuck with conservatives blocking things all the way along. So here we have another one,
Yes.
and I guess the spin on this is to embarrass the conservatives because they're blocking every crime bill that's making things tough.
Well,
How's it making it tough for drivers?
so it's meant to respond to the recent court decisions that have struck down a bunch of mandatory minimums, which, again, appeasing to the conservatives because they want the mandatory minimums back.
They were the ones who put them in, all those unconstitutional mandatory minimums.
Yeah. And then secondly, it's meant to respond. I mean, it does a lot of things, but the two things that are important to driving law, it's meant to respond to court delays. And specifically not allowing judges to throw cases out if they're not tried within a reasonable time.
So background here, we've talked about it before, the Jordan decision of the Supreme Court of Canada. The court had enough, really. They had enough with many cases over the years of stupid delays that caused accused people a world of pain. And set limits on it. So 18-month limit basically from the time the charge is sworn to the time it should be resolved in court for a simple summary matter, and 30 months for an indictable matter, which can go to a higher level of court, a Queen's Bench or Supreme Court, whatever the case. You could have a jury trial. And the idea there was that if it's a complex case, like really complex, that you could go beyond that. And there's lots of complex cases that happen that do require that. But most cases are fairly straightforward and should be resolved within that time period, provided the resources are there. And the state has the resources of the state.
Yeah. In fact, they can put more resources into court if they're concerned about delay.
Like every case where we've had delay potentially, and I don't know that how many we've argued, we've floated it a few times. We've had to give notice of it and then won on other issues. But every case where there's been a delay that we've had, it's so squarely had fallen to the Crown for something they didn't do that we alerted them to, that you alerted them to.
Well, except that one case where I lost my delay argument.
Well, but there always was issues, especially after in the immediate post-pandemic world of your trial scheduling.
Yeah. So the bill essentially says no longer can a judge just automatically stay proceedings because the Supreme Court of Canada said that's the only remedy. Is nothing lesser that you can do. It's a stay of proceedings or it's nothing. The bill says actually, you can't just stay proceedings for delay because you have to take into account a number of things. And one of the things in the Jordan decision they talked about was a complex case. So this bill defines what constitutes a complex case. And it includes cases where there are pretrial applications. So your applications to exclude evidence under the charter, arguing your charter rights were breached, those are pretrial applications. They don't happen before the trial starts. They're counted towards the delay currently, but going forward, if you have a voir dire on a charter breach, which is so many criminal trials, then you are going to basically have to eat that delay. So you have to choose between arguing your rights were violated by the police or arguing your rights are violated to be tried in a reasonable time. One right or the other, but not both.
So in the vast majority of cases, there's some sort of pretrial application. In sex assault cases, the pretrial applications are usually vast and relate to things that are actually specified in the criminal code that you have to have a pretrial application for. And then in the impaired driving context, it's almost always voir dires because you've got the police officers are the ones engaging with the individual. Like that, it's not like a situation where it's a theft and an internal employee theft. It's a situation where the police make the detention, arrest, demand, all of those things are pursuant to the criminal code. Warrantless search that is only authorized by the criminal code for breath demands or blood samples or something like that. So
Okay.
every one of them, all of it, from the arrest on, is all engaging charter rights, and there are balancing of charter rights in those cases all the time. But there is always charter rights engaged that require investigation. Like that is most of the case in an impaired driving case.
Yep. So big problem. But it is going to, I guess, we'll have to see if it passes. But the other thing in impaired driving cases that are pretrial applications that you can't bring unless you bring them pretrial and specific on specific timelines in the criminal code, if you want to cross-examine the qualified technician, got to bring an application before the trial. If you want to get further disclosure of something related to the breath samples because there's some indication of a problem, you've got to bring an application. So any time where you conceivably actually have a defense to the impaired driving case, you will not be able to argue your right to be tried within a reasonable time was violated.
And so much of it is disclosure. Like so much of the delay is disclosure.
Yep.
The delay is almost always for us, Crown not getting the things that we've identified are meaningful and relevant that have to be disclosed.
Yep.
Or important and have to be disclosed, or maybe important and have to be disclosed.
Correct.
So this is really Parliament, instead of properly funding and ensuring that the resources are there. And it's not always just an issue of money. It is also an issue of organization. And we deal with government day in, day out, and you see the organizational steps that take place there. You wonder like how any government office gets anything done, but because there's so little pragmatism, but really it's just failure to address their steps to meaningfully get things on. Make sure there's enough judges, make sure there's enough prosecutors, make sure police officers provide the information that they've got to provide. And what would you have? No serious delays. Rarely would you have a delay that was not falling at the feet of the defense.
I mean, barring a lack of court time, because cases are triple booked.
More, as I say, more judges,
more
courtrooms, more prosecutors. Just make sure that you've got the sheriffs, make sure you've got the people there to do it. Like the problem is that it costs money to have a justice system, and we see that they do everything they can to have an injustice system because it's much cheaper. Like that's the whole idea of IRPs in BC. But in the end, like it's part of a democracy. You have to, these are the cost of doing business is to have a functioning court system. And if you keep your court system perpetually crippled, then this is the result. And don't just go start taking away rights. Anyway.
As you talk about the underfunding of the system and sort of interestingly, the culture of complacency with respect to delay that Jordan was meant to kill is in fact being enshrined into law now. It reminds me of another provision in Bill C-16 that I didn't think about this morning when we were talking about it. that would also impact impaired driving cases, and that's the 490 provisions.
Oh, yeah. So, I mean, go ahead and explain it. When the police sees something like an item, they've got a timeline.
Yeah, they can only keep it for 90 days before they have to return it or file an application in court for further detention. And when it comes to impaired driving cases, if you provide a urine sample or a blood sample, inevitably the police have to file one of these applications because the lab is under-resourced. They're not testing the samples within the 90 days. Half the time the police aren't even sending them for a month anyway.
Yes.
And they aren't getting the information back. And in crash cases, accident cases, they have the 490s that they have to do. They have to file the application when they get the black box from the car, the collision data recorder, and the airbag control module.
Any information that they're extracting from the vehicle.
The data extraction takes time, and so they're often filing the application for those items too.
Is this a rubber stamp? Like, first time out, it's a rubber stamp. The second time out, then they've got to actually explain themselves. But the first time out, quite literally, rubber stamp. We need this. This is the reason we need it.
Yeah.
Give me judicial authorization to continue to hang on to it.
Yeah. It's not exactly hard to get it, but there's been a sort of a growing trend of frustration among justices that the police are really engaging in a lot of inaction. Or are not adequately explaining why things cannot be done sooner, right? Like, why can the lab not test a blood sample in 90 days? Like, how hard is it? It's not that hard. You can do it in a day.
Yep. And police have tried all sorts of things. They try to get people to consent to it without being properly informed. They try all sorts of sneaky things.
Yeah.
But yes, the police are frustrated because there are occasions where it's quite reasonable that it's going to take a lot longer. But those are the times, complex investigations when, okay, I see it. Other times I'm looking at it going, come on, like, get it done.
So they're going to extend the timeline, change the timeline from 90 days to 180 days. 6 months.
Double it.
6 months.
So they doubled the timeline in order to lay a charge in an indictable offense in previous legislation. And they did that to be able to give the Crown an extra 6 months in indictable offenses, summary offenses rather, to get the matter to court, basically to extend the Jordan from 18 months to 24 months. And now they want to extend their timeline to hang on to stuff, which basically just allows them to hang on longer before they lay a charge.
Drag their heels longer. And how reliable is that blood and urine going to be after 6 months?
Well, the problem is we can't challenge the reliability of it. So we have a huge problem in this country that we've already got, substances that are tested somewhere where you can barely find out what they did.
Yeah.
And they don't keep any notes or records like they do. Like, I'll tell you, in the States, when blood goes to a lab to be tested, they can trace the entire thing all the way. And that lab analyst, exactly who did it, when they put it in, what lot they put it in with, and how many others went in during that lot to be tested. And all the maintenance of their equipment, you can find out. All of that is disclosable. In Canada, almost impossible to get any of that information, and that person's never going to have to testify anyway, so they don't even feel any obligation to follow the same steps.
Wow.
We have this really, really arrogant, stupid arrogance in this country sometimes, but arrogant assumption that the police, that the RCMP are doing things right. And anytime we dig, we find they're not.
And if you look in the U.S., when lawyers access that data, they often find out that the analysts at the lab are fudging the results.
Faking
it. So, and they get copies, they get copies of the police report when they send in the sample. So they're reading about people who died and stuff like that. You can imagine how they might be emotionally compelled to
put
fudge
that finger
the
on the
results.
scale.
And when I did the first of the 4 courses you have to take to become a lawyer scientist. The first was my gas chromatography course, the same thing they use to analyze the blood samples. I learned how very easy it is just by changing the programming on the batch to make a sample have double, triple the result.
Yes.
Just by changing how it interprets the data.
Yep. Well, I mean, we've seen cases where there's hospital blood and there's RCMP blood, and they differ vastly.
Yep.
So
yeah, just had one recently. So that's concerning. And then the other thing in the bill that I was originally planning on talking about was mandatory minimums.
Yes.
So the federal government is trying to impose a safety valve, which is interesting because it's been something that the Senate has tried to do and the federal government has rejected. This is not Senator Kim Pate's safety valve legislation. It's a shitty safety valve. But it is a safety valve nonetheless. So in cases where a judge finds that imposing the mandatory minimum punishment of imprisonment is cruel and unusual punishment, then the judge has the permission under the legislation to impose a lesser term of imprisonment. Still has to be jail.
Yeah. That it's so unfortunate that it's all is founded on a misunderstanding of what happens in court. I don't sit in court that often anymore, but I did for years and years. I've watched hundreds of people be sentenced, and very rarely, if you sat there and sat through the whole thing, would you, as an objective observer, have a problem with the sentence that was imposed, because the vast majority of the time, the judges are right in the zone. I don't always agree with them, but they're usually right in the zone, like very defensible, reasonable sentences. And that discretion is important. And it's not that every judge is perfect, that's for sure. I mean, there's lots of judges who have some significant problems I've noticed also over the years, but it doesn't mean that we need to have a legislative override that doesn't take into account all of those things about the offender and the nuances of the offender and the offense. And every time they try to do this, it just backfires on them.
Yeah, and ends up costing the taxpayer millions in all the various constitutional challenges that would not need to be brought.
There's plenty of offenses that have a very, very minor level, way that they can be committed. They can be so minor and not justified jail. And if they set mandatory minimums of jail, and it must absolutely be jail, I don't know, could be challenged as well. I suspect it will be challenged as well.
Oh, for sure it will be. Yeah. But the driving law element of it is they specifically write in the bill that the safety valve provision does not apply to impaired driving offenses.
Well, that's because they wanted to make sure that
you get your 30 days or your
120
days.
Yeah, it's the thing, the mandatory minimum that has not been struck down.
Yeah. And, it also only applies to imprisonment, so it doesn't matter about your driving prohibition.
Yeah. It's amazing that the impaired driving is the most morally blameworthy thing you could possibly do. When we sell the alcohol, we know it takes away your ability to make good decisions, and alcoholism is a disease and it's addictive.
I mean, I like to joke that I'm a drug dealer.
Why? Because
I sell alcohol.
Yeah.
Alcohol's a drug.
Well, caffeine's a drug too. So Tim Hortons, they're drug
dealers.
Also, I bought that opium bagel that time.
Yeah.
Poppy seed bagel, or tested positive on a drug test 5,000.
Anyway, yes. Yeah, no, impaired driving itself is morally blameworthy, but
oh, absolutely. It's putting everybody at risk in a fundamentally selfish way, and it's and people who are not, like children. It's putting children at risk. It's putting just innocent people at risk. It's putting everybody at risk.
But it's weird that you can get out of a mandatory minimum jail sentence if you sexually assault somebody, for example, but you can't get out of a mandatory minimum jail sentence if you drive drunk.
Blew 110. Drove up to a roadblock.
100.
Drive up to a roadblock, blow fail into an ASD, drag back to a police detachment, below 100. You get the mandatory minimum. You have a criminal record.
It's ridiculous. Anyway, so that's Bill C-16. There are a lot of problems with it. I'm breaking it down problem by problem on my TikTok in a series that will probably take a long time to post because there are so many things. And I'm not even touching the sex assault provision.
You have a lot to go on your TikTok.
Yeah.
There's Kyla's got probably 1,000 TikToks she should make. I think she should make 2 a day. She thinks she should make 1 a day. And it's just, I think she's got to start making more. I'd like everybody to chime in on the comments of her TikTok and let us know whether or not she should do more than 1 a day.
All right. We've used most of our podcast time talking about Bill C-16, but it's important and people should know about it. So I'm okay with that.
Yep.
Let's lighten the mood.
We have something to lighten the mood?
Yeah, we have.
The ridiculous driver of the week.
This is a good one.
Yes. So you and I very recently completed a trial involving a particular highway in British Columbia, Highway 97.
Well, and I was driving on Highway 97 in the Okanagan just last week. In fact, I called 911 to report a suspected impaired driver.
Yep.
On this same route of highway in between Oliver and Penticton.
Yep. Anyway, the headline on CBC reads, "Oh no, not again. BC family sees 4 crashes into backyard in 3 years. 4 cars have crashed from this highway into their backyard, and the most recent one?"
Yes.
Was a CVS officer.
So commercial vehicle inspections and enforcement.
Yep.
And so it's a Suburban, a Chevy Suburban. And these are supposed to be the most careful drivers. They're the ones who are out there on the road all the time, monitoring the trucks that are traveling up and down the highways and byways of British Columbia, checking their brakes and making sure that they're safe and enforcing speed enforcement and everything. But this time on this corner that you would think they would know very well, they missed the corner again. And as 3 others have recently, and launched themselves into somebody's yard.
Yeah, and 2 of them were within 48 hours.
Oh.
Yeah. But I also think it's important to note that the CVSE officer crashed because he was involved in a chase of a pickup truck and took the curve too fast, which is concerning because I don't think CVSE should be engaging in chases. I think pursuits are dangerous and they're not supposed to happen.
I think catching up to somebody who's just passed you, and you can...
That's one thing.
That is one thing, but if it's a chase, it's another. So it depends on how it was characterized. And this may have been mischaracterized, but...
Yeah, it is a story, so it could be characterized wrong. But.
Yeah, but certainly there are many occasions where it is unsafe to travel, but you would think that they would know that highway and know that corner. I've gotten to know more intimately many of the highways in this province over the summer because I've been driving around delivering alcohol to private liquor stores throughout the southern half of British Columbia, right up to the Alberta border.
Yep.
And I've got to know of all of these corners where like the lights are flashing and it says go slow down to 40. You actually slow down to 40. And in the snow, you slow down to 30. You would think the CVSE officer would know about this particular corner.
Yeah, very concerning. Anyway, but very funny. I think that these people who own this property, one of the crashes was a boat that had just been replaced by insurance from a previous crash. I think they need to stop storing things in that part of their
Well, we think that the things that they want to get replaced, like maybe they want an insurance to replace, where they've got a dream of, shit, that car's got a bad engine. It's kind of knocking these days. I don't want to fix it. Let's just park it where somebody will smash into it. It'll be written off and then we'll be covered.
Yeah, it's so weird. All my grandmother's expensive jewelry was there and it got burned up in a crash. Fiery crash.
You could take all your broken china and put it in the trunk of your old car.
I was transporting it to be appraised.
Yeah, exactly. I just got the appraisal back.
Yeah. Don't commit insurance fraud. Just FYI, we're just joking. We're lawyers. We're not advising you to commit insurance fraud.
Please don't. The other thing is you might be tempted to put in some poles with concrete in it, which would just lead to somebody dying probably. So it's such a difficult situation. I'd be, thinking of how I would modify my property to try and reduce the potential for damage, I suppose. But I'd also be concerned because I don't want to be the cause of somebody's death who drove around a corner too fast.
No, you should be asking the province to put in, there's different mechanisms that have been engineered to deal with crashes while reducing the risk of death.
Exactly.
And that's for the government to do.
Exactly.
And there we're back at it, Paul. The government inadequately resourcing the highways for safety.
Isn't it complex what the government must and should and do? And yet, you've got these libertarian types who want the government to do nothing. I don't know. You're just going to sit in a field. Of course, we live in a society, and this is what we need: is we elect people for this purpose and hope that they do a good job. But once again, my fundamental point about the failure of democracy is that the things that matter to us never are things that will lead to a government being overturned.
No.
So no government's ever going to be overturned for being perceived as tough on crime.
Well, except for photo radar.
Well, the photo radar was different. Yeah, that was the rare occasion, but there was so many other things too.
There's fast ferries.
But it's like almost never is it if you are absurdly tough on crime, if you come up with a system where the police don't even have to collect the evidence, all they have to do is make the allegation, like we have almost with the IRP scheme, then people will not. You won't have an election on that issue.
Nope. Well, that's our podcast. If you have a driving law related issue or you want to comment on how many TikToks I should post, you could find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law.